In a very significant order, the Bombay High Court on Saturday, 14th August, has stayed the application of two of the central government's controversial new IT rules, which were enacted earlier this year and which require digital news media publishers and other online publishers to adhere to a code of ethics prescribed by the government, and for this to be enforced through a three-tier grievance redressal mechanism. Now, this order was passed by a bench of Chief Justice Dipankar Datta of the Bombay High Court, along with Justice G.S. Kulkarni. This is not a final determination on the constitutionality of the rules. This is an interim order at this point, staying these two rules, because it's considered that for them to continue without any interference would have a pernicious effect on the right to freedom of speech. Now, the petitions in question here were filed by legal news portal The Leaflet, as well as journalist Nikhil Wagle, who have argued that these new IT rules introduced by the government earlier this year, that they are unconstitutional because they violate the right to freedom of speech, and that they go beyond the scope of what the parent act of these rules, the Information Technology Act of 2000, allows. Now, what we're looking at here are the Information Technology Intermediary Guidelines and Digital Media Ethics Code rules of 2021. Rule 9.1 and 9.3 have been stayed by the Bombay High Court. And these are rules which have actually been challenged throughout the country. It's not just here in the Bombay High Court. In the Delhi High Court, the Quint, the Wire and others have also argued that these rules are unconstitutional. Legal news portal Live Law has filed a petition in the Kerala High Court saying the same thing. There are petitions in the Madras High Court. So there are a lot of cases which have been filed against these rules. Now, what exactly is the problem here? Is there something really wrong about requiring media publishers to follow a code of ethics? Now, that's sort of what Rule 9.1 does. It says, we're setting up this code of ethics, you've got to follow it. Rule 9.3 has to be read with it because that creates an enforcement mechanism. And it says that first off, there has to be, if anyone who feels that there's a problem, that any person who reads something on a website and thinks that the code of ethics has been violated can now approach the media publisher and say, we think you violated the rules. If they're not happy with the response they get, they can take it to a self-regulatory mechanism set up by digital news media publishers. And if they're not happy, then again, this goes up to a government committee which can decide whether or not there's been a code of ethics violation. Remember, there's no involvement of the judiciary here. No court determination that the law has been violated. This is all up to the government, and it's up to a person's personal perception. So that's sort of what the real concern is here. Now, a number of other rules have also been challenged in all of this. It's not just these two aspects, but the court has not ruled on those. It's only said it needs to pass a stay on these two aspects which come in from these rules. Now, why it's done that is that it says, and I'm going to quote here, that the indeterminate and wide terms of the rules bring about a chilling effect qua the right to freedom of speech and expression of writers, editors, publishers, because they can be hauled up for anything if such committee so wishes. This is that government committee which we mentioned. The 2021 rules are thus manifestly unreasonable and go beyond the IT Act, its aims and provisions. Now, why exactly is that the case? Because, you might have heard that there are similar code of ethics and rules for even print media, even for there's a program code for TV media to follow. So what's the problem? Well, what the Bombay High Court also, it agrees with what the petitioners have argued here, is that they said that, look, the rules which are there for the press, which is the norms of journalistic conduct of the Press Council of India, which are in fact are the basis largely for this code of ethics. They said that that's a moral thing to follow. There's no statutory law which then which allows print media to be hauled up by someone on that basis, or the government to start censoring them on that basis. There is a program code which TV news follow, but there is a parent act there which sort of creates the basis for that, rather than it just being something which is created out of these rules. Because the Information Technology Act itself doesn't say anything about regulation and censorship of conduct. It allows blocking of certain websites in very, in certain circumstances, but it doesn't deal with regulation of the content itself in the way that these new IT rules do. And, that's the consistent theme raised by petitioners across the country, and the Bombay High Court has agreed with that on a prima facie level, as we said. They've not passed a final ruling. And some of the other things now, I'm going to just read out what else they've clarified here. They've said, as it is, the constant fear of being hauled up for contravention of the code of ethics is a distinct possibility now. People will be starved of the liberty of thought and feel suffocated to exercise their right to freedom of speech and expression if they are made to live in present times of content regulation on the internet with the code of ethics hanging over their head as the sword of Damocles. This regime would run clearly contrary to the well-recognized constitutional ethos and principles. So this is very, very significant because one of the concerns about these new IT rules is that it doesn't even just apply to established big organizations. Any sort of online publisher, even someone writing a blog, could potentially be hauled up for these kind of violations. And that is a chilling effect on free speech. That is censorship, which the Constitution does not allow in a sense. Now, there are reasonable restrictions which can come into place on certain things, but there has to be a law brought in place for that. There is no underlying law here for this kind of regulation which is being done, and that's something which the Bombay High Court recognizes. It finds that there is no basis to say that this is all just on the basis of the IT Act. It's going beyond the scope of that, and that's why they've passed this order. So a big step towards protecting freedom of speech on the internet by the Bombay High Court. Here, the matter isn't ended. In September, they'll be taking up further hearings. There's going to be other hearings in the matters in the other high courts. Even the Supreme Court might take it all up. So stay tuned to the Quint for all those updates, and do follow us for everything which is going to happen in terms of protection of your freedom of speech online.